Good afternoon, Judge Norman.
Good afternoon, Chief Justice and the commissioners.
Are you well?
I'm very well, thank you.
Good. Are you ready?
Yes, Chief Justice.
Well, you don't deserve any sympathy.
No.
You grilled people
That's
sitting there
my
for 3
fear.
years.
Thank you.
Okay. Judge Norman, you hold AB recent LLB degrees from the then University of Transkei,
That is correct, Chief Justice.
and then did certificates in shipping
Yes,
and in project management.
that's correct. Yes.
Now, in respect of the shipping one, you did not end the you had a stint in New York in a shipping law firm. What was that about?
Yes. Well, first of all, Chief Justice, one of the reasons I went to KZN is because I did my pupillage there, and one of our lecturers, Mr. Advocate Maniwick, SC, was one of the specialists in shipping law. So he was always drumming it into our heads that one of us must actually do it. So I took interest in it, and I joined the Maritime Law Association, and it was through that. Then there was invitation for people to apply to be trained in New York to law firm Holland and Knight, which does that training on a yearly basis. They take away foreign students, and I went there as a trainee, and that was in August of 2004, and returned in January of 2005.
So you were there for 6 months.
Yes, but the training is quite intense, because if there has been a collision at sea, then they do in America what is called depositions. So they receive all the evidence immediately after the collision, and that's a formal process. It's like a court sitting, but it's headed by a senior partner, and the law firm where I was attached to is one of the leading law firms in maritime. And I was trained under Mr. Rambush, who had appointed certain Mr. Hooper, who was voted that very year one of the leading maritime specialists in New York. So then also at the same time attended Fordham University. The law firm organized that I attend that university on a weekly basis, lectures on a weekly basis, and we were lectured by one Professor Sweeney, and anyone who is in the maritime business knows a lot about him. He used to practice within our shores here. He would fly from New York to come and do cases here. So I got the benefit of being lectured by him in maritime law. And I went to state district courts with the partners of the law firm, and I prepared opinions. Whenever there was a maritime issue, they would invite one to prepare opinions for them. And they had a series which was called Rules of the Road. That series dealt largely with maritime matters, and I was asked that year, because I was there, to update that series. And I had the pleasure of being told the following year, after I had left, that my ideas on the series had been accepted at the seminar that they had held after I left. That benefit of having been exposed to that led to me being able to work and be a junior to now retired Judge Wallis, Justice Wallis, and he led me in several maritime matters. And then thereafter, I got the support. There were people like Tato Tsaute, they were employed by the Port of Durban at the time, and they were legal advisors there, who were just giving me work in that field. So that's how I got a lot of training, and I then imparted the skill to some of the juniors as well. And I'm happy to announce maybe that 2 of those juniors have now they've got master's degree in maritime law. Yes.
That's quite an achievement.
Yes.
So you ended up being an expert in shipping law yourself.
In a way, yes.
Yeah. I remember the excitement in the Eastern Cape Division of the High Court at the prospect of having you appointed to that court with your expertise, which is
Yes.
rare, especially in black law practitioners.
Yes, yes.
Are there who else?
There's very few, but in Durban, the class is quite huge in Durban. But I think the challenge is whether they want to come into practice or they get employed by the ports authorities and the maritime authorities, because there's various bodies within the maritime industry that employs them. So you don't get to really see a lot of them within the court setting.
Yeah,
Yes.
pity. All right. So to go back to your judicial career, which was preceded by a few things you did before you became an advocate.
Yes.
You 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 started working for the Sky government.
Yes, as a prosecutor, immediately when I qualified after my BUris degree, I was employed to prosecute as a district prosecutor in the old Sky.
Yeah,
Yes, and
for 2 years. No, actually longer. You were a public prosecutor for 2 years, then you
yes,
went up
and then
the
I
ranks
left
as
to
a-
do my LLB
Yeah.
again, and then I went back again to being a state advocate
Yes,
in the Sky. Yes,
and that was another 3 years in that department.
that's correct. Yes.
All right. And you list having held the position of senior legal administrative officer.
Yes.
What
This was
did you do there?
This was during the transition stage from the homelands to this new government. And at the time, they were setting up different offices, and I was invited to apply for that position because they needed someone who had the knowledge of the law in the area. I don't know what else they considered, but I was asked and I applied for that position. And I was attached to the office of the Director General, Mr. Tozamile Bota at the time, and it was when, in fact, they didn't even know what to call my title. I think I became the first senior legal admin officer. They didn't know what title to give to a person holding that position because they had state law advisors. So I was not a state law advisor. But then they created, I think Mr. Zem Titus came up with that title.
One of the best state law advisors.
Yes.
Black state law advisors this country has seen.
Yes.
All right, then you went to do your pupillage at the Durban Bar
That is correct, yes.
and practice there.
Yes. After pupillage, I came back to the Eastern Cape. I practiced in Bishop for about 5 years.
Yes, you did.
Yes. Then in 2002, then I relocated then to Durban. Yes.
And you practiced there, took silk in 2011.
Yes.
And then did a few other things while you were practicing, including
Yes.
working for the State Capture Commission. How long were you with that commission? 3 years?
The state capture.
Yeah.
The state, yes, for 2 years, Chief Justice, because although I left at the time COVID set in, I actually finished with the commission at the end of that year because there were still some reports to submit. Yes.
And then some people persuaded you to make yourself available for the bench.
Yes.
And thankfully you agreed.
Yes, I did. Thank you.
All right. You've acted at the SCA already.
I have, yes.
When?
I started in December last year until June of this year, and I am acting currently.
Until
yes,
when?
Until end of November.
All right.
Yes.
And that reserve judgment you listed in your
That was delivered
it was delivered a while back.
Yes, on the 15th of July. Yes.
Okay. You've been involved in a lot of things. You have been involved with our legal bodies, the BLA, AFT, SAULA, GCB, and you've held senior positions in their executive committees and chaired others, and so on.
Yes.
And the LPC, and now you are a member of the South African chapter of
Yes.
The women
That is
judges,
correct, yes.
which is all a woman judge can be really, with
Yes.
all the restrictions. All right. What else am I leaving out? Your CV is long. No, I'll stop there and leave it to the other commissioners to tease out what you have to offer to this position.
Thank you. Thank you, Chief Justice.
President Muleme.
Thank you, CJ. Good afternoon, Justice.
Good afternoon, President.
How are you?
Good afternoon. Thank you.
Okay. How did you find the transition from being a permanent judge of the Eastern Cape Division to being a justice of the Supreme Court of Appeal?
I found it quite enriching and enlightening. I think the beauty about acting at the SCA is the ability to get all the researchers that assist with the work that you're doing. That's a plus, because in the high courts there aren't too many researchers, and even if we are too many for them to actually focus on something. And secondly, the support that you're getting from the judges when you go and you seek support, and I got that a lot. And the environment, and also the type of the work that you come across. I mean, with those petitions, you move from civil work to crime and to, I mean, everything is just there. In a week's time, you would have covered a range of legal matters. I found the environment quite conducive, and also enabling one to be able to produce good work because of the support and the manner in which the court, because it's an old machine, it runs like an old machine, and you know that this is what you've been given, this is what you need to do. I enjoyed that a lot, yes.
Yes. Would you say that you have been exposed to a wide spectrum of legal work at the SCA?
I have from tax law, from my judgments, they are on insolvency law, tax law, on contempt of court, on criminal law, those that I have written or co-scribed, and also the petitions themselves, they really do, because you have to discuss that petition with a senior judge. That too, it also enriches your knowledge in all spheres within the legal profession. Yes.
Yes, and if my memory serves me well, you have been a panel member in some of complex appeals where the record of appeal was actually voluminous.
Yes.
Including the one that you will be participating in.
Yes.
In November.
Yes, that is correct. Yes.
Did you find that it was easy to deal with such complex matters?
I found it quite easy because I've practiced a lot in that court. As an advocate, senior counsel, in fact, I've appeared more at the SCA than I've appeared at the Constitutional Court. So you always just know that because there's different ways, you know that you will not be getting heads of argument that are 100 pages, things like those. So you always know how the system works from having practiced there as a practitioner, and also having read a lot of documentation as well as a practitioner. You always develop a particular system of how you read. And once you've managed that system and you read, then it becomes easier to look at what the issues are. Then by the time the matter gets heard, you have an idea exactly of what the case is all about. And you can't therefore be found to be wanting when questions have to be put to the practitioners.
Yes, thank you very much. In fact, your response accords with the reviews that have been given about you by, in fact, all the law bodies that responded. So
thank you.
It accords with that. Thank you. Thank you, Judge Norman. Thank you, CJ.
Thank you, President. Thank you.
Minister?
Thank you very much, CJ. Good afternoon, Judge Norman.
Good afternoon, Minister.
How are you?
I'm very well, thank you, Minister. How are you?
I'm okay.
Yes.
I got interested and I listened as CJ was going through with you the issues, the work that you're doing in the maritime. I think it's quite exciting.
Yes.
And quite rare to find. And what intrigued as I was looking at this and listening to you, because one of the issues that has been raised by Asia African Legal Consultative Organization has been that both in terms of developing countries, we do not have quite sufficient growth or even have not done much in understanding the law of the sea and supporting the work that needs to be done there. But also we are found wanting in terms of development of rules, laws and policies just that regulates that. That's why I got excited when I saw your work, because it's something that I started working on maybe earlier on this year, just to look at what we can. So what do you think we should be able to do to pay attention to this area? And I noted that you're saying in Devon we've got quite few, but they do not come into the legal space. Are you maybe able to share what constrains them from coming as a pay? It's whether the areas offer more, because if you do in terms of the work, either you as an advocate given that work, because it's companies, they normally tend to pay much better compared to other cases. But what do you think it's the issue, and what is it that we need? I'm looking at what is it that we need to do to unlock this area of work for more potential of the country to be able to be competitive, as we know that this is a growing trade area beyond just having approvals of your cargo ship and offshore drilling. Thanks.
Thank you. Thank you, Minister. Well, first of all, I think the country does have an interest because it's a trade issue. So it means it affects everyone. I remember in 2004, there was a conference in Vienna where COXA, which is the Carrier of Goods by Sea Act, was going to be amended. And the US, because it preferred certain trade relations and was key, and it was running with that workshop, and South Africa was not represented. And I wrote to the Minister of Transport when I was in the US, and I said, I've just been roped in to assist the US in improving its trade relations with South Africa and the amendments that are being sought, but South Africa is not represented. And I got a response almost immediately, and I was happy to be told by the partner that attended the conference that South Africa was indeed represented. Coming back to what can be done, it's a very big industry. That transport industry, the marine, the fishing, all of that is a very huge industry. And government can do so by simply making sure that from the universities, those students that have an interest in maritime get the kind of exposure, even if it's going to create. I remember Portnet in Durban, they were funding students to study maritime law. Not only that, but they were giving lectures and seminars so that students can actually get the practical feel of what happens within that world. But also within the practice as practitioners, it becomes very difficult to simply swim in as a junior. You've got to have a leader that's going to introduce you to it, because it can be quite complex and it needs somebody who really is going to be able to lead that path. But also and you find that it's only a few places that have it within government. You'll have it in Durban where you've got the ports, then it's easier to have it. So I think it's a question of really creating some seminars and inviting students to come so that they can decide where they want to go. And if the state has got a few that the state can look at and say, we want you to represent us, then the state could do so. I remember Professor Hay, who is also a lead in maritime, used to complain that government was not doing much to really attract the skill within itself, because you need to have, in fact, he was even suggesting that a maritime lawyer must actually head a particular division that has got, that deals with maritime matters. So I guess it's a question of really marketing it within government so that people know that there is this, and also making sure that because you get involved in that litigation, you use them, those that have been trained as well. Yes, thank you.
Thank you.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Judge President.
Yes, I'm limited to one question.
Yes.
So I'll try and contextualize it. Under the judgments that we have listed as having been reported, we've
Yes.
got one in which we have dissenting judgment by Kun J.A. with Unterhalter J.A. concurring. And the third one is the state versus Tabete.
Yes.
And we note that it's co-written with Skippers J.A.
Yes.
Are you free to share the circumstances in which there had to be a co-scribe or you had to co-scribe with someone? Was it capacity issues or was it something juicy on a point of law or what?
I do not know. I think the president allocated it to us, but I think the volume in that matter was huge. And the legal questions that were involved, I think there were about 13 legal questions that had to be decided in that matter. And because I had also, well, we worked together as a team. It was not a question of anyone. We were working even on Saturdays. It was like, in fact, it reminded me as if we were back in practice, because we would be at chambers until late in the evening, just debating the issues. And then once you get to your place, he gets to his place, he phones, he says, Thandi, I think we got it wrong there. I think let's just debate it again. So it was such a pleasure to work with a senior judge on a matter such as that one, because it involved a lot of questions of the law, which are quite intricate, which most times people just overlook it. For instance, a person doesn't unpack common purpose. A person will simply say, well, they acted in common purpose and leave it at that. But that judgment caused us to literally unpack all the components of the common purpose doctrine. So we worked at it like that, yes. Thank you. Thank you.
Thank you very much, CJ. Maybe just to explain a little bit about co-scribing. It's something that has always been done at the SCA. So it really depends on the presider. So the presider may allocate the matter to one scribe or to two scribes.
Yes.
I've already asked Judge Skippers about a matter where he co-scribed with Justice Wallis back in the day. And in responding to that question, he referred to this one, that he is the one who decided, I think he explained that he's the one who decided that due to the complexity of the matter, there should be two scribes, and he allocated co-scribing duties to you. Thank you, CJ.
Thank you, President. Yes.
Commissioner Mangen.
Thank you, Chief Justice. Good afternoon, Justice Norman.
Good afternoon, Commissioner.
Yes. Mine is it's not a really question, but I would want you to clarify a disconnect that appears on the matter, the reserved matter of Sheriff Giani and Makwibele.
Yes.
In the questionnaire, you gave the date of 19 May 2024 as the date on which the judgment was reserved.
That was an error. I apologize for that.
It was an error. Yeah.
It is an error. Yes.
Okay. The actual date is the 19th of May
2025. That is correct.
Thank you. The LSSA did pick that up and asked that it be clarified.
Thank you. No, it's 2025, Commissioner.
SAFLI records it as 19 May 2025, which is the correct.
That is correct. Thank you.
So there's no problem with delayed judgment on your part?
No, not at all. Thank you.
Thank you so much. Much appreciated. Thanks,
Thank you, Commissioner.
Yes, you were not at the FCA in 2024, were you? Well, in May 2024 at least.
Yes.
All right. Commissioner Marumakai?
Thank you very much, CJ. Good afternoon, Judge Norman.
Good afternoon, Commissioner.
Most of the times when I read the judgments of the High Court, it appears to me that there are times when the rules of that court are referred to assist in one or more of the matters before the court.
Yes.
It doesn't seem to be the case in as far as the rules of the superior courts are concerned. Um, the cases that I've read, it doesn't seem like the rules are assisting in terms of the things that needs to be done in those courts. And for me, and I'm not saying it's wrong, for me, it brings some curiosity to find out whether the judges of the court that are where those rules are applicable. One, they are aware of those rules, but most importantly, those who aspire to go to that court, they are aware of those rules. So my question is based on that.
Yes.
So now, having said what I've said, when you look at the rules of the Supreme Court of Appeal, in the definitional section, they give you a sense of how you compute the days when you need to operate in that court. They will say you need to use court days.
Yes.
And they give a sense as to how you actually compute court days.
Yes.
And it, among others, it excludes from 16 December to 15 January.
Yes.
But when you look at the rules in totality, they also refer to things done within a month. And that appears quite a lot. Actually, in my counting, about 13 times in the rules. And you find that for you to do a leave to appeal to that court, you need to do it within 30 days.
Yes.
I mean, within a month. And it doesn't seem to be clear to me as to how one interprets what a month is and how do you calculate a month. I'm not sure if this is something that you have thought about, and how do we reconcile the computation based on the court dates and this 1 month that appears so much in these rules?
Well, I think when we were taught, I think at university, the reasoning was always that once a month is mentioned in an act, we know automatically it's 30 days. And then if it's a month in terms of the rules, it would be a month in terms of the court rules. But I haven't looked at the definition of a month in the SCA rules.
No, there's no definition. That's where the problem is, yes.
So the 30 days would be the 30 days then. If it talks about a month, it would be the 30 days.
But is that not a problem, though, that perhaps maybe we need clarity as to how, and consistency? Because when you look at the magistrate court rules, it's clear. The rules, in as far as the rules are concerned, the dates, in as far as the rules are concerned, you know, it's court dates. When you're looking at the Magistrate Court Act, you know that you are dealing with court dates.
Yes.
The Superior Court Act also, and the uniform rules, it's also clear. Even in the Constitutional Court, it's also clear. But with these rules of the Supreme Court of Appeal, it appears to be a problem. Shouldn't there be clarity on actually what we are referring to when we are computing the days of that court, so there's no confusion?
Yes, maybe, but when I used to practice there used to be some rules that would say within 10 court days. But I understand the question that you're asking. I haven't thought about it, but to the extent that it is so, maybe it might need clarity. But I never struggled when I was struggling to understand how to compute them, because I think I must have had reference to somewhere in the rules in order to be able to compute the 30 days or the 10 days within which to file, let's say, an answering affidavit or replying affidavit. But I will have a look at what you're raising. Yes.
Thank you very much, because there's an issue about condonation that comes
Yes.
out of these things, and that's where the
Yes.
confusion is. But thank you very much. Thank you, CJ.
Yes.
Commissioner Gotsa?
Thank you, Chair. Good afternoon, Judge.
Good afternoon, Commissioner.
Sorry, Judge. You described your experience at the SCA acting as
Yes.
enriching, enlightening, and you said it was quite a conducive and enabling environment. So I just want to see, or to maybe just clarify,
Yes.
whether that was your overall experience, even in dealing with senior judges.
No, it was until, well, maybe just one uncomfortable experience is when I dissented in one matter where I could see that the judge was really upset that I was going to write a dissenting judgment. But other than that, the collegiality was there, and the manner in which the court is. I mean, the tea room is possibly the size of just slightly smaller than this, and we sit exactly the same way. during tea, and you converse with people. So that environment, I think it has changed from what it used to be in the past, because at the time when I served in this body, we had people had a different experience. Yes, thank you.
Thank you.
Thank you, Commissioner.
Commissioner Trolley?
Thank you very much, Chief Justice. Good afternoon.
Good afternoon,
Judge
Commissioner.
Norman.
Yes.
You specialize in maritime law,
Yes.
and it might not include maritime and environmental qualifications, but what are your thoughts about the fact that we are not able to adequately patrol and prevent the exploitation stroke overfishing of our marine resources along our extensive coastline and marine territory? Because it has a direct effect and impact on our economic well-being as a country.
Yes. Well, I think it's because, first of all, the people that practice within that industry, your fishermen are usually people that come from very poor communities. And the regulations, as we know them, they're usually very stringent. And you've got the quotas that apply. And you've got people on the one hand who are desperate for housing, who are desperate for food. On the other hand, you've got the laws that say you cannot fish up to a certain level. So I think for me is one needs to understand exactly where the difficulties are. But those who own vessels, they're thriving in that industry because they're able to get permits. They apply, they get permits. But the question is, how do you then link the people that actually depend on this very industry for their survival? How do you manage it in such a way that there is progression without people breaking the law all the time? And I mean, the Port Elizabeth area, for instance, is rife for abalone theft and all sorts of things that they do there. And in as much as one would say, look, they are doing it, but to enrich themselves because they sell all of this. But it's different when you go to Cape Town, where largely the people that fish there are very poor people that need to do these things or to fish in order for them to survive. So I think the debates, maybe they will have to go back to what the minister had indicated, that the industry, I think it does need some sort of total overhaul. People do not understand, for example, what is it that they could take or they could not take. I don't think there's enough information out there that would alert people as to what they need to do or what they do not need to do. If you go to the areas like Mzamba, the Wild Coast, you will find people along the road carrying fish, and then you ask yourself, they're selling it, it's hot, it's in December. By the time the person buys it, in what state is that fish going to be? So it's all those little things that one has to look at in order to actually look at how best to enrich the industry. Yes.
Thank you. Chief Justice, can I just have a follow-up, please?
Yes.
I know you said we must restrict that. I'm thinking more in terms of exploitation of our marine resources in our marine territorial waters by illegal fishing by foreign vessels.
Yes. No. I hear you. I'm sorry, I missed your question. Well, there are laws for that. We all know what the law is. There's different jurisdictions at sea. You know that from the baseline up to 12 nautical miles, there's a certain jurisdiction that falls within a certain jurisdiction. So the maritime authorities, I think it's called the Maritime Authority, but Transport Authority, Maritime Transport Authority, they are quite aware of those things, and they know exactly why they should be arresting those vessels. I have given orders in Port Elizabeth, arresting vessels for having done the very same issue that you're raising. Yes. Thank you.
Before I forget, this disturbing issue you raised about a colleague who was annoyed because you had given an indication that you were going to write a dissenting judgment. I find that extremely worrisome because that's precisely the kind of behavior that gave that court the bad name you used to enjoy and which we fought so hard to eliminate.
Yes.
I hope you brought that to the president's attention and it was dealt with and dealt with firmly.
No, I didn't. I brought it to the presider's attention.
All right,
Yes,
and
yes.
it was dealt with.
I think the presider dealt with it, yes. Thank
All
you.
right.
Thank you, Chief Justice.
Commissioner, sorry, Jivan,
Covered, thank you.
you covered. And Steinbeck?
Hi,
Yes.
Judge Norman.
Good afternoon, Commissioner Steinberg.
Sorry about that. There's a peanut gallery behind. I want to engage with you about your dissent in the lion match case.
Yes, yes. Thank you.
Lion match versus SARS.
Yes.
Firstly, the GCB points out that the fact that you dissented is indicative of your independent-mindedness, and I must say that anyone who knows you knows that you're certainly an independent-minded woman and judge.
Yes.
They do, however, say that you erred, and it's not the erring per se that I want to take up with you. It's this. 4 judges wrote a judgment, and it dealt with the tax court and the full bench had both refused a postponement that was brought on the morning of the appeal. The 4 judges went as far as to say that had the tax court granted the postponement, it would have been a travesty of justice. And it quite carefully sets out the facts surrounding the timing of when the applicant, Lion Match, knew that its attorney was withdrawing, who made the affidavit that was before court, and so and so. Your judgment in dissenting engages only with the full court judgment. I don't see, for example, the full court, the affidavit on which you rely. The full court says, well, it was a hearsay affidavit. And clearly it was, because it was a part-time secretary who deposed to it, not the applicant itself. The full court says that it's common cause, that that Lion Match knew about the withdrawal a month before the hearing. You say 10 days, but you don't engage with the reasoning of the court. I'm concerned when I read that, because as the reader of the judgment, you feel like you're in 2 different cases. And I would just like to hear your response. Finally, what was big for the majority was that the attorney was also a director of Lion Match. A lot of your judgment turns on the fact that it was the attorney who pulled out, not the company who fired the attorney. But the attorney is the company, the attorney is a director of the company. And all of these facts are very well laid out in the majority judgment. But you write your judgment as if they're not there. And I just want you to respond to that.
Yes. Thank you, Commissioner. First of all, the appeal itself it lied against the decision of the full court, not against the decision of the tax court. So that is why I addressed the judgment of the full court.
Sorry, you misunderstood me. I was saying, why did you not address what your colleagues in the SCA had said?
Why didn't I?
The majority said, for example,
yes,
this affidavit's hearsay. That is not something you took into account when you relied on the affidavit.
Oh, okay.
So that's what I'm referring to. I'm sorry if I wasn't clear.
Thank you. All right, thank you. My understanding of the affidavit I relied on is the affidavit from SARS, because that is there. It's part of the record, where the official from SARS says this matter is a very complex matter. This matter is going to require experts. So I use that affidavit to say, when you're weighing up the reasons for granting a postponement as a tax court, you ought at least to have considered that affidavit, because it was telling you that it's a complex matter, it's going to require experts to deal with it, and I do not see that. The second part of your question is, the inquiry about that matter did not just end at what happened with the withdrawal. It goes further. There is a letter that gets written by the attorney directly to the judge. And that letter finds itself in the judgment that the judge gives. And that letter is written after the matter has proceeded, it has been heard. I think it was sent sometime in December. And that letter is quoted in full by the judge in the judgment. The full court says the act of someone writing to the judge directly is inappropriate. It's there in the full court's judgment. So I'm saying then, in my judgment, if then the full court found that the sending of a letter to a judge is inappropriate, then why not then find that the postponement process as a whole ought not to have happened in the manner in which it happened?
Judge, I'm sorry, it's not really the question I'm asking. The question I'm asking you is, all of the issues you raise are answered and dealt with by the full court, by the 4 judges who wrote the majority judgment. I'm asking whether it isn't appropriate to then engage with how you come to different factual findings, let alone legal ones. So it's a question of principle.
Yes.
When you dissent, don't you think you should engage with what the majority found?
Yes, thank you. But I did engage with what the majority found in my judgment. Maybe we could go to it, and I'll point out to you where sorry, I just want to find. The lion match is not part of the. Sorry, the lion match is not part of the bundle, but I might have to download it quickly. But I do engage on 2 aspects. For instance, the full court. I'm so sorry. The majority says that the full court the tax court was correct in saying that. I beg your pardon. The full court was correct in saying that the whole issue of a conflict of interest was a red herring. I deal with that fully. First of all, I say, an issue of a conflict of interest between a lawyer and a client is a privileged issue. The tax court and the full court, they say in their judgments, they ought to have been told, when did this conflict arise? What was the nature of the conflict? The details of the conflict. So I say in my judgment, when it comes to a conflict of interest, as practitioners, we all know that a lawyer needs to just stand up and say, my lord or my lady, I'm withdrawing for the matter. There has been a conflict of interest. And I refer to international authorities in that regard. Because it's such a privileged issue, it cannot be expected of a litigant to say, these are the reasons that there was a conflict. And in any event, it was common cause here that the directors of the law firm called in this particular attorney and said to him, we think you must withdraw from this matter. Then the timing becomes critical, and I deal with it in my judgment, because the full court and the majority judgment, they say they knew about it 3 weeks before. Now let's go to how did they get to know about it 3 weeks before. Then I start with what was sent to the litigant, notifying the litigant that we are withdrawing. And I go to that notice and I identify that they relied on the old rule that said, where you withdraw as an attorney, you must do so by sending registered post. So I say, If then it was accepted that that notice was sent, but then the court didn't ask, where is the registered slip? Because that's the only thing that will tell you when it was sent, and we do not have it. So my submission was, my finding was that there were too many issues that ought not to have been resolved in favor of SARS in that matter. Because if, for example, you say, no, postponing a 10-day trial because your attorney has now withdrawn, that is going to inconvenience the court, inconvenience everyone. But you've got rules that say when you inconvenience me, I penalize you by mulcting you with costs on an attorney and client scale. SARS gets its money, doesn't have to be out of pocket because of that, but also, especially in this particular case, because of the complexity that SARS had acknowledged. Now look at what happened then. In the end, because postponement was refused, then expert evidence was led, could not be cross-examined because the person was affected, and also the nature of the tax issue. The tax issue related to capital gains tax, where shares were valued before the promulgation of the act, but then SARS had to assess them as if, I think there's a certain clause, transitional clause in that act that allowed it to do that. Now, at that point then, it's such a critical matter, such an important matter for any taxpayer that you would want to be heard on it. Now, you don't get heard because your attorney is withdrawn, and you ask for a postponement, yes, belatedly, I understand that, but then you are deprived of an opportunity to place your case before the court. And how then I dealt with how I found that the full court erred. So my understanding is I dealt even with some of the findings of the full court, of the majority in that judgment.
You don't mention the majority judgment once expressly. And the key findings, like the affidavit is hearsay, and that the director is the applicant, and therefore the applicant knew. None of that is engaged with. But I don't think we can tap.
No, I don't think. Yes, it's a pity because I don't have the judgment here. Yeah, if I had thought I would be asked, I would have brought it. But I do deal with the findings that they make, and maybe
we actually do have the judgment up front here.
You do have it?
We have it, and President Mulemela wants to say something.
Yes, thank you.
Yes, thank you, CJ. We do have the judgment, and there are references to the first judgment. The first reference is at paragraph 55, and that's in relation to the affidavit, and then there's another reference to the first judgment at paragraph 64 and the paragraphs following that one. I'm just responding to the Commissioner's statement that there's no reference to the majority judgment even once. It's referred to as the first judgment.
I stand corrected. Thank you, President.
Yes,
Could I just follow up, Chief Justice?
Yes, have you finished, Commissioner Steinberg?
Thank you.
All right, Commissioner Ngoitwa?
Good afternoon, Judge Nome.
Good afternoon, Commissioner Ngoitwa.
Yeah, I don't know, when you left the Eastern Cape, maybe you thought you'd be back now. Oh no, where are you, in Bloemfontein? Driving 4 hours to Bloemfontein. Yes. Anyway, I want to ask you this point around a dissenting judgment.
Yes.
Now, forget about this other judgment, Lion Match. I didn't read it, so I don't know much about it. But the judgment I did read is a selective empowerment.
Yes.
Where you wrote for the majority.
Yes.
And it's the same thing I noted, but not by you, but by the dissenting judgment by Judge Kuhn.
Yes.
That you end up with two judgments which diverge from each other. Yes. And reach different conclusions.
Yes.
And it's not the first time I've seen something similar in the Supreme Court of Appeal, where you get a second judgment. It does not explain to the reader what is the point of disagreement. Unlike the judgments of the Constitutional Court, where each judgment engages substantively with where the points of disagreements are, which for me is a very important discipline, because if you did that exercise, you would actually find that there are no points of disagreement, or the points of disagreement are much narrower than it appears. But that selective empowerment case, references your majority judgment once in one paragraph.
Yes.
The rest of the time, it just goes on its own direction.
Yes.
So it made me wonder, what exactly is the process by which judgments are produced by the Supreme Court of Appeal? And is there no scope for colleagues to sit across the table and to say, I see point A this way, I see point B this way, but is there really a disagreement? Or can the two coexist in one judgment?
Yes.
Or whether someone just writes their own and the other writes their own and then they both get published?
No, thank you. There is a coherent system within the SCA. The scribe in that matter of selective was actually Justice Kuhn. He was the scribe. And I then indicated that I was going to write a dissenting judgment in the matter. So then there is a certain process that gets followed. That's where then you get to see that somebody is not happy with you writing a dissenting judgment. Is going to, for instance, if you are a scribe, everything else that, just like in the sheriff's judgment, I think you referred to the sheriff's judgment. In the sheriff's judgment, I was the scribe, and there was a dissent to my judgment. But you do everything as a scribe, including even the numbering of paragraphs, including the dissenting judgment, because you are the scribe. That's what I was taught. It's your responsibility. So things happen slightly differently in selective. So you will find that in selective, because a judgment had been written, with me having indicated that I was going to dissent, and then the other judges then went with the dissent that I had written, you'll find that in certain instances, it's, in fact, there's little things that you can notice about that judgment. I refer to him as my brother. Nowhere does he refer to me as my sister, So it's those things that are quite telling, that it's not really an accommodating environment for the dissent, but our judgments are completely different in selective. They are very different. That was one of the reasons that I just had to write a dissenting judgment. But other judges have seen it in the sheriff's judgment, where the other judges accommodate your dissent within that judgment, because the scribe is doing it. And they will say, for instance, you don't have to repeat the facts in paragraph 35 because they are contained in the dissent in paragraph 42.
Well, in selective empowerment, they are repeated in both judgments.
That is the thing, yes. So I think it just depends on who you're dissenting, whose judgment you're dissenting to, and how that person accommodates your dissent.
Yes, and also it's odd because the dissent starts, it's the first judgment. That's why I couldn't understand what I was reading. And then when I get to the end, I realize, no, there's another judgment.
Oh.
That's your judgment.
Yes.
And then the two are not speaking to each other. So maybe that's not something you can help, because you're trying to get into that court. Maybe when you are there, you can help it.
No, maybe I could just mention that although mine was a dissenting, it ended up being the majority. So because then it ended up being the majority, then it ended up, how shall I put it? Yeah, I think that's what perhaps caused...
That was the cause of annoyance. An MBA acting judge managed to sway.
Because what I would have expected is the dissent, at the very least, will say, these are the points that Judge Norman has found. She has misunderstood the record.
Yes.
She has misunderstood the law, etc. Your judgment is just ignored.
Yes, true. Yes, thank you.
Thank you, Sir.
You were the last on the list, then there were all these follow-ups. All right. Judge Norman, it does appear that we've reached the end of your interview.
Thank you. Thank you, Chief Justice.
Thank you very much.
Thank you very much. Thank you to all the commissioners and chief.